Are you a self-represented litigant going to court for the very first time in your divorce process? Hi, my name is Laura McGee, and I'm the founder of Leave Strong Divorce Coaching. And I want to share with you today some tips and strategies to make your first court appearance a little more successful. I was a trial attorney in Canada for a number of years, and I spent a lot of time making sure my clients were prepared to show up the way they wanted to be heard in their court hearings and in mediations, because really oftentimes it's a very similar experience. So let's start with what you look like. You don't need to look like the attorney just because you don't have an attorney. What you do need to do is come so that you're comfortable, clean, and presentable. You want the judge to hear you and not be judging you based on your physical appearance. Make sure that your voice is going to speak for you even louder than what you're wearing. Secondly, prepare in the way that an attorney would prepare. You need to find out how long the judge has set aside to hear your issues. And know that you only have that much time. They might have some flexibility and some bendability, but once you've reached the limit and they have a courtroom of people to hear, they're going to be pushing you to finish and you won't get yourself heard. So how do you do that? Organize yourself in terms of issues. This is what the court wants to hear about. Here's my evidence, and here's where you're going to find it in the documents that I've already prepared, served on the court, and shared and served on my spouse. So you need to line it up issue by issue with your evidence, and you need to actually practice. Get yourself in front of your video, in front of your mirror, in front of a friend, and run through it. Time yourself. Make sure that you can be heard, your points can be made, the evidence will be in front of the judge, and you do it in a timely fashion. Time's going to be critical. You do not want to save the best for last, because you may not get to last. You might get interrupted, you might get asked questions by the court, and you might find yourself completely sidetracked and come out of there going, oh my God, I didn't say the most important thing. So these are important tips. Finally, have a summary ready. And the summary needs to be a summary of what you've already said. Don't expect that the judge has found the right focus or the focus that you want to give it. Hit the high points, create a summary, and let the judge know what exactly you want. What is the outcome you're expecting? Be succinct and precise. If you're looking for a child sharing plan, for example, or if you're looking for a child sharing specialist to do an evaluation, don't come in there umming and ahhing and saying, well, whatever you think. Go in there with your plan of action and perhaps a backup, an alternative, where you're saying, this would be a best case scenario and here's why, and here would be a second best case scenario and here's why. You need to be able to answer the why question. These are some basic fundamentals of being able to prepare yourself to speak in a very nerve-wracking environment where you know decisions are going to be made in a flash about your life. If you do have to go to court and you are self-represented, prepare. Don't leave this to chance. If you're looking for tips and strategies to get you through this difficult process, please join me here at leavestrong.com. There's a community of people that have all kinds of wisdom to share with you, and you will find that there'll be some nugget in there that's just right for you. Laura McGee, Leave Strong Divorce Coaching.